So, late last year, Donald Trump, President of the United States, signed an executive order in which the United States government would not recognize the citizenship of children of people who do not have legal status in the United States, that he would ignore the 14th Amendment to the United States Constitution, something that is the highest law of the land, and just blatantly not grant citizenship status, not grant citizenship documents from the federal government, and not recognize their citizenship. Now, he has claimed, as do his supporters, that the 14th Amendment does not apply to the children of illegal aliens. That is utterly 100% false. Now, first, there are generally speaking two kinds of citizenship, and most states recognize one or the other. Some states, like the United States, actually recognize both. One is jus soli, and the other one is jus sanguinis. The United States actually practices both. Jus soli are of the soil, meaning that if you are born on the territory, with certain very narrow exceptions, you are a citizen of that state. Most states in the Western Hemisphere practice jus soli citizenship. And then there's jus sanguinis. Jus sanguinis is basically of the blood. That means if your parent or parents are citizens of the United States, you are also a citizen of the United States, or whatever country is in question. So in the case of the United States, if both of your parents are citizens of the United States, you are a citizen of the United States regardless of where you were born. If one person is a citizen of the United States, their child will become a citizen if that citizen parent meets certain requirements. Okay, so for example, my children were born in Taiwan to a Taiwanese mother. I'm a U.S. citizen, and I was able to pass my citizenship on to my children because I met those residency requirements. So the United States practices both, and so the question is, of course, the 14th Amendment was proposed by Congress and ratified by the states shortly after the Civil War. And so, one thing that people actually don't want to even address is what was the status of citizenship in the United States prior to the passage of the 14th Amendment? Well, the United States actually practiced birthright citizenship. It predates the 14th Amendment. In fact, it even predates the United States itself. Citizenship based on birthright, based on soil, goes back to English common law, and this was the colonial practice under English common law, and this was the practice in the early decades of the United States, sans 14th Amendment. 1844, Lynch versus Clark. Now, granted, this was a state case in the state of New York, but the judge involved looked at the citizenship practice of the United States. And in that case, the judge ruled that the child of temporary visitors was a citizen of the United States based on the existing common law that was already in practice and had been practiced since colonial days. This practice was never actually brought into question until 1857, in what is one of the most dreadful, no pun intended, one of the most dreadful Supreme Court decisions in the history of the Supreme Court. Now, Plessy versus Ferguson is also on the list, but this is a pretty bad one. 1857, Dred Scott versus Sanford. In that case, the United States Supreme Court ruled that the U.S. Constitution was not meant and was never meant to give people of African descent citizenship in the United States. This was actually the first challenge to the notion of birthright citizenship. So, shortly after that, Civil War. After that, the Civil War is, of course, the Congress and the states want to make sure that this is not going to happen again, and that anyone born in the United States is, in fact, going to have their citizenship regardless of race. Yes, the question in point here was of an African American, but this applies to all. It does not just apply to African Americans. So, if you look at the 14th Amendment, the very first article, it's a rather lengthy amendment, and actually there were other parts of the amendment that were more controversial at the time than this. But what it says is, all persons, focus on the word persons, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. pretty clear. It was clear at the time that that the debate occurred in the 1860s. It was clear to all present what that phrase "subject to the jurisdiction thereof" means. It is really today only Trump supporters who are ignorant and do not understand the notion of jurisdiction. So, first of all, it says all persons. So, this is not simply a reference to black persons. The debate today is, again, it's a matter of jurisdiction. So, let's take a look at what was said in the Congress at the time that this was being debated. Senator Jacob Howard, okay, Michigan, quote, "This will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to to the government of the United States, but will include every other class of persons. Will include every other class of persons. Trumpkins, take that." This was in the debate on the Senate floor when it says it will include persons of the United States, it will not include persons of the United States who are foreigners. It is referring here to those who are the families of ambassadors, which is actually right to the point of being under the jurisdiction of the United States, because those who are accredited to the US government are not subject to the jurisdiction of the United States. Others who would not be subject to the jurisdiction would be members of an invading army who are in wartime occupation of parts of the United States. Obviously, they would not be within the jurisdiction of the United States. And at that time, the whole Indians not taxed, meaning basically Indians who had allegiance to their tribes, lived on the reservations, and they remained outside the scope of this until the American Indians Citizenship Act in the 1920s. But anyone else born in the United States, you are a citizen. Senator Edgar Corse of Pennsylvania, he actually opposed the amendment on this very point because he did not want this amendment to allow Asiatics, Chinese, or Gypsies, Romani, to be able to become citizens under this amendment. So Edgar Corn, he knew exactly what this amendment was saying. He knew that anyone born in the U.S., with that very narrow exception, would be a citizen. And he did not want that because he did not want Chinese to become citizens, and he did not want Gypsies to become citizens. He did not want Romani to become citizens. Another senator, Senator John Konis of California, he also reiterated that it would apply to all who were born on U.S. soil, again, with those minor exceptions. So, has there been another case on this incident? Yes, there was, 1898. The Wong Kim Ark case, okay, United States versus Wong Kim Ark. And again, this whole phrase, subject to the jurisdiction, came into consideration in this case. And so the court ruled that this was looked at in light of English common law, looked at in light of the practice that had already existed for decades in the United States before the amendment was ever proposed by Congress and ratified by the states. The justices involved, and it was a 6-2 decision. It was not a close decision. It was a 6-2 decision. And they specifically outlined the exceptions to this case. Diplomatic representatives, which have already been mentioned, hostile occupation of an occupying army, already mentioned, children born on foreign vessels, not mentioned, but okay, obvious exception. And again, natives who had direct allegiance to their tribes, something that would still be in place until the 1920s. Okay, everyone else was fully subject to the jurisdiction of the United States. If you are an illegal alien and you are in the United States and you commit a murder, of course you're subject to the jurisdiction of the United States and to the state in which you committed that murder in. Any other reasoning beyond that would be lunacy. Okay, now the argument that some do make on the Trump side, the Trumpkins, they suggest that it's not a matter of being subject to the laws of the United States. It's a matter of being the complete subjugation to U.S. authority, which they claim that illegal aliens are not subject to. And okay, you can argue that point, except that the Supreme Court addressed that in the Wong Kim Ark case and rejected it. The two dissenters did, in fact, bring that point up, but they lost in a 6-2 decision. So the Supreme Court has already ruled on this point, and if you look at the framers of the amendment and you look at what they said at the time in the late 1860s when this whole thing was going down, they made it very, very clear. All classes of aliens, of all classes of children born in the United States, with those narrow exceptions, would be citizens of the United States. End of discussion. End of story. Trumpkins, read a book.